The classification of a terrorist affects a variety of legal rights, such as whether he has prisoner of war status or under what conditions he can be captured. Legally speaking, what is a terrorist? Is he a civilian who committed a serious criminal offense, or is he a soldier who committed a war crime? In the complex world of modern terrorism, courts and governments are finding it difficult to classify terrorists according to one of the existing definitions. Is there a need to create a new international category that will relate specifically to terrorists?
So good afternoon. I got an early warning that before I speak there is a video, but I forgot it. So this is the meaning of early warnings. I'm glad to open the third panel of the conference dealing with the law of terrorism. I'm also glad to note, after listening to a fascinating panel about proportionality, that our panel has a much better proportion of women and men. We have lecturers. And I would like to congratulate the organizers for this really amazing and important event. Thank you very much. And before giving the floor to our distinguished speakers today, I would like to make some introductory remarks. Almost 80 years have passed since the first attempt of the international community to adopt a comprehensive treaty against terrorism. The 1937 Convention for the Prevention and Punishment of Terrorism, drafted by the League of Nations, had never gained the required number of signatories, and thus was abandoned. The international attempts to agree on a comprehensive legal tool to fight terrorism were renewed during the 1970s due to the increased incidence of international terror acts, such as the hijacking of international flights and taking of hostages, and so on. But because of the political controversies over the definition of terrorism, reflected in the famous dicta, one man's terrorist is another man's freedom fighter, the result was a series of specific conventions dealing with certain manifestations of terrorism. The rise of Al-Qaeda in the last years of the 20th century led to renewed efforts by the international community to adopt a comprehensive tool against terrorism. An ad hoc committee was established within the Legal Committee of the United Nations in order to negotiate a comprehensive convention. In parallel, the General Assembly in 1994 and the Security Council in 2004 adopted resolutions containing what seemed to be a definition of terrorism without saying it explicitly. Similar technique appeared to be used in the Convention for the Suppression of Financing of Terrorism adopted by the United Nations in 1999. These implied definitions led the late Professor Antonio Cassese, sitting as the president of the Special Tribunal for Lebanon, to conclude that there is an agreed definition of terrorism in customary international law. But so far, his opinion remained controversial. In the meantime, a dramatic development took place. Whereas during the 20th century, most national and international activities against terrorism were limited to the law enforcement paradigm, the 21st century saw the rise of the use of force paradigm, especially after the September 11 attacks. This development brought a new set of questions regarding the legal framework applicable to the fight against terrorism. Do states have the right to self-defense against terrorist attacks? Is it an armed conflict? What type of an armed conflict is it? Who are the parties to the conflict? Who can be attacked and in what conditions? What circumstances? Who can be detained and in what conditions and circumstances? And so on. Another important question is what is the relevance, if any, from the perspective of the laws of armed conflict, and I thank Professor Jeffrey Cohn for reminding us the difference between that and IHL, to the fact that the adversary is a terror organization. Does the new situation obviate the need to have an international definition for terrorism? Our distinguished panelists will try to respond to these questions. So without further ado, allow me to introduce the first speaker. I would like to introduce each speaker before his presentation. So the first speaker will be Professor Rachel Van Landingham. Professor Van Landingham is an associate professor of law at Southwestern Law School. She has served in the US Air Force for more than 20 years, retiring as a lieutenant colonel in the US Air Force Judge Advocate Corps, General Corps. She advised in this, during her service, she advised to the US Central Command on legal issues related to the armed conflicts in Afghanistan and Iraq, and served as Central Command Chief Liaison to the International Committee of the Red Cross. Professor Van Landingham is the Vice President of the National Institute of Military Justice. Please.
so much, very much for being here. And I like the analogy to women and the proportion on the panel, even though I think Nitsana counts for five men, so it makes it proportional. Thank you, Nitsana and Shurat HaDin and Robert for the wonderful invitation and privilege to be here today. But I like the analogy to women for another reason. That is, as a woman who joined the Air Force in the 1980s when President Reagan was still president, a woman, in order to get any kind of respect, had to meet the standards, not meet the same standards as men, had to exceed the same standards as men. Instead of just doing 5 pull-ups, I would do 10 because that was the standard for the men. It wasn't fair, but that was the reality. And Israel doesn't just have to meet the law of armed conflict requirements, it has to exceed them, and it still is criticized and not given the respect it deserves, and that's not fair. But it is reality. So what can and should Israel and the rest of the world be doing about it? And that is, in essence, an education and information campaign. Today, the New York Times has an article on a proposed Arab League joint armed force, as well as another article highlighting the growing international criticism, not that Israel is receiving in its prosecution of armed conflicts, but that Saudi Arabia is today experiencing, based on reportedly high levels of civilian casualties in Yemen. I think the Israeli Defense Forces should be asked to teach this new Arab League armed force, if it ever materializes, as well as Saudi Arabia, about the application of the law of armed conflict, because the IDF is so good at it. My point in bringing those articles up, what's good for the goose is good for the gander, and what is good is the extant current law. I welcome the chance to be back in Israel. I was here in February. I do hope to be invited back. But I do disagree with the title of this conference and part of its premise. I do not believe we need a new law of war, which is really code, at least it was for George Bush, for less restraints in warfare. We need a better understanding around the globe of the current law. In February, I delighted in being for several days a guest of your IDF. I've also gone to school with members of the IDF, and they demonstrated effectively how the IDF tactically won Operation Protective Edge by following the extant LOAC. It works. The IDF didn't have any calls for reform in the law. They simply were explaining the law in application. Contrasted with today, I've heard many voices falling prey to the same narrative of victimhood that Nitsana said the world helps the Palestinians perpetrate, but instead that victimhood was seemingly applied to Israel and its military forces. Calls for a more permissive LOAC and killing human shields sounds like a Hamas television ad, telling the world that, see, we were right, Israel does want the legal veneer to kill more civilians. No, it doesn't. There is work to be done in the realm of the law of armed conflict, but what needs to be done is not a revolutionary push for new law. The vital work that needs to be done today is both more basic and more difficult. It is to increase the understanding of the current law, but to increase the understanding of how the extant durable law of armed conflict applies vis-a-vis highly sophisticated enemies with state-like capabilities operating with radically different value sets, enabled by communications technology unimaginable even 25 years ago, in a milieu which sees increased alienation and desire for a sense of purpose among disaffected and often economically challenged youth whose ability to be globally recruited into non-state actors and is enabled by the same technology-driven globalization that's contributed to their sense of alienation in the first place. But simply because the operating environment is complex does not mean that the law, which implements specific core principles, has to be as difficult, particularly when we're educating target audiences. But of course, the law of armed conflict is changing, but that doesn't mean there needs to be effort wasted and distraction caused by calls for a new law. In fact, both the use ad bellum regarding the legality of the resort to war and the use in bello regulating the conduct of warfare are dynamic. And I would argue that all effective law is dynamic. It is changing. Increasing the understanding of the law of armed conflict today involves a dedicated process of rigorously analyzing the governing LOAC in actual conflict scenarios, such as we heard the earlier panel today beautifully discuss the not just proportionality principle, but in the critical precautionary process that precedes the proportionality principle. Such analysis will incrementally evolve the law as appropriate, and it takes into account any newness in the operating environment, such as unrestrained urban warfare in which the enemy intentionally places its own civilians at risk in order to exploit civilian casualties. How and why the intentional use of the capture of soldiers by opposing forces to exploit the strategic benefits of such kidnapping for ransom, how that affects the concrete and direct military advantage gained under the proportionality analysis, that is the kind of education that is needed around the world, and that is how the law will incrementally, incredibly, and rationally evolve. I do want to emphasize that the law of armed conflict, at least regarding the regulation of warfare, is relatively clear, with the bulk of the same rules applying equally in both an international armed conflict between and among states, as well as what's been termed a non-international armed conflict with transnational armed conflicts against non-state actors nested in the latter. But it's how the legal rubber hits the road in such complex environments, which needs better explication, as the enemy will do it for us and for you to sway public opinion in its favor, as those in the audience know too well. States can strategically benefit from a clear articulation of the rules, especially applied in urban settings. We have to be careful what we ask for, because if we ask for a new law, we may just get it, and it may not be the one we want. The human rights community, particularly in Europe, has been calling for a new law of armed conflict. They've been calling for a merger of the law of armed conflict and human rights law, as members of the last panel noted. I attended the American Society of International Law's annual conference in Washington, D.C. 2 weeks ago, as I have for the last few years, and it was taken as a matter of course when there were numerous speakers got up and said, the merger's already happening, and it's a great thing. It's not such a great thing. So the law can change in 3 different ways. The incremental application, change in the law as it's applied in changing operating environments. There is the merger of international human rights law into the law of armed conflict, which isn't all inappropriate. In the areas of the treatment of prisoners, there's much that can be gained, particularly regarding procedural safeguards from human rights law. And we heard an earlier speaker today mention the modes and methods of investigation, which are more clearly explained and detailed in international human rights law. That's fine. But the merger of a less harms analysis, as in the duty to capture versus kill, which is non-existent in the law of armed conflict, and shouldn't be, because it makes the law of armed conflict even more, it makes it less humanitarian and upsets the balance. That's what needs to be pushed against. But there is also the ways for change in the law, and it's a method that I disdain, and it's typified by ill-advised individuals such as President Bush in 2002, when he called for new laws in the global war on terror because those quaint Geneva Conventions simply weren't sufficient. Well, that didn't work out too well for the United States, and the United States had to deal with the strategic losses it suffered because of that attitude. That kind of blatant call for less restraints dangerously upsets the LOAC's equilibrium, and in the long term is strategically unhelpful. It may win a battle, but not the long war, because it forgets that the LOAC is already predicated on the social harmony and peacetime that is only possible when combat takes into account humanity alongside military necessity, and it forgets the moral compass that Professor Korn elegantly pointed out, the moral compass that the law already provides to our soldiers. So I have not spoken much about terrorism, and I'm happy to take questions after my presentation on terrorism. For me, the word terrorism is irrelevant in the law of armed conflict outside of the specific prohibitions that already exist For example, Article 51, Paragraph 2 of Additional Protocol 1 prohibits the acts or threats of violence, the primary purpose of which is to spread terror among the civilian populations. Otherwise, the law of armed conflict and its trigger for its application is very fact-based. It's not the emotional-based or social construct of terrorism or a terrorist. Is there an organized armed group that is inflicting violence of such an intensity that we resort to our armed forces, appropriately so, in order to prevent them from achieving their violent, evil ends? If so, it's an armed conflict. The law of armed conflict is triggered, and the law of armed conflict makes no distinction between a terrorist or a freedom fighter. They're either an unprivileged belligerent or they're a privileged one, and the law has already said that they're not privileged, and therefore they can be killed in that armed conflict, and they should be. Thank you so much.
Thank you, Professor Van Landingham. Now allow me to introduce Professor James Shuttler. Professor Shuttler is adjunct professor at Georgetown University Law Center, where he teaches national security law. In addition, he is assistant general counsel for a United States energy firm, where he advises on public and private international law in the field of nuclear energy. He served for 30 years in active duty and reserves as a U.S. Army Judge Advocate, retiring in 2013 as a colonel. During his service, he was an assistant chief of the Army Judge Advocate General Corps International and Operational Law Division, where he contributed to the DoD Law 4 Manual. Professor Shuttler's last duty assignment was with the Defense Prisoners of War Missing Personnel Office, where he served as Deputy Counsel and Staff Judge Advocate. Please, Professor.
Thank you very much. Let me just begin my remarks first by thanking Shurat HaDin for this invitation. It's wonderful. It's my first visit to Israel, and I'm very much looking forward to it. It's a beautiful country. Thank you. So let me start off by saying I'm here in my personal capacity. None of my remarks, of course, are on behalf of any of the organizations that I have worked for now or have worked for in the past. I also come to you as an American academic and not as an expert on the situation here in Israel. So please take my comments from that perspective. I also want to point out that in this presentation, we're talking about the definition of terrorism. We're also talking about the law. So I want to distinguish the law from policies that might be adopted in dealing with terrorism under the law, which can be very context-based. So I'm going to try to focus, if I can, just on the law of armed conflict, and the other law frameworks we've used, to talk about them a bit and maybe some ideas, but I do want to make sure you all understand that in discussing this, I'm talking about the law as it exists and not sort of on the broader scope, which was discussed earlier today, which having to do with things like rules of engagement, policies that are chosen by states to do. They never can do what the law does not allow, but they might choose to do more than the law requires, and that's an appropriate choice for a state to make. Or not make if it wishes to go to the limits of the law. It can, just never can go below what the law would allow. So I guess the title of the panel is whether terrorism is an independent target or should be an independent target of international law. And when I read that title and the accompanying description, I wondered what it would mean for terrorism to be an independent target, either as a subject of international criminal law or as possibly a new field of international law. As to the potential to develop international criminal law to cover acts of terrorism, I would say that many situations of armed conflict, acts of terrorism are already crimes, even if they aren't called terrorism. For example, direct attacks on civilians or indiscriminate attacks that don't distinguish between, on the one hand, civilians and civilian objects, and combatants and military objectives on the other hand, are certainly crimes under international law today. There is need for improvement in the law in order to punish those who deliberately increase collateral damage resulting from attacks by another party. Indeed, I would favor criminalizing such acts through a further development of customary law and, if possible, treaty law, and I will turn to that subject later. But as to whether to create a new body of terrorism law, my personal impression was not favorable, at least initially, if the result would be to provide authority to use force against terrorists and terrorist groups beyond what is already permitted by the law of war. In my personal opinion, the law, and I'm talking here about the law of war, already provides adequate authority to target terrorists who are waging war against the state. And any loosening of the limitations that are already applied under that law to the robust authority to use force which it grants can only delegitimize the law, in my view. I look forward to hearing the views of this conclusion from others in the panel, and your views as well, but please let me briefly explain my point of view. In the aftermath of the attacks on September 11, 2001, as Professor Van Landingham mentioned, the United States did consider the possibility that terrorists fell into a gap in the law that gave them essentially no rights under the law of war. The Bush administration argued that al-Qaeda was engaged in an armed conflict of international scope against the United States, but was not and could not be party to the international treaties governing the international armed conflict. Therefore, members of al-Qaeda and associated forces did not enjoy the benefits of those treaties. Instead, so the argument went, as long as al-Qaeda terrorists were kept outside the United States, which would have given them the protection of U.S. domestic law, they occupied essentially what was a no-law zone, a law-free zone, international law-free zone. And in this zone, the U.S. government enjoyed greater flexibility to deal with these terrorists, including the use of enhanced interrogation techniques, detention of so-called black sites to extract intelligence, restrained only by a policy of humanity, but not a legal obligation. The legal theory underlying this special status for al-Qaeda terrorists was highly controversial, ultimately led to abuses, and was rejected by the U.S. Supreme Court. Instead, the court in Hamdan v. Rumsfeld, in a case dealing with military commissions, held that the law applicable to non-international armed conflicts, or NIACs, including the baseline humane treatment standards found in Article 3 of all 4 Geneva Conventions, did apply. Taking its cue from this case, the U.S. Department of Defense embraced the view that Common Article 3 applied to the conflict with al-Qaeda and associated forces, and this is where things stand today. So for the United States, at least, there is no such thing as a no-law or law-free zone for terrorists under the law of war. So therefore, assuming we're not talking about creating a law-free zone for dealing with terrorists, then I guess the question for us is whether the law we apply to terrorism today is adequate, and if not, whether we need to change the law in some way. It's generally understood there are 2 potential sets of norms to consider in dealing with terrorists. First, there's the so-called law enforcement paradigm. Under this paradigm, terrorists are treated like common criminals. Only the minimum force necessary is used against the terrorist, meaning the state will try to arrest or capture the terrorist before resorting to force. Further, if the state does resort to force, the force used must be proportional to the threat posed by the terrorist, and lethal force is only used where it is absolutely necessary. The state cannot shoot and kill someone just because he or she belongs to a terrorist group. He or she must be engaged in activities that represent an imminent threat to others at the moment force is used. Under international law, this law enforcement paradigm is most often associated with international human rights law, IHRL they call it, which prohibits governments from arbitrarily depriving individuals under its jurisdiction or control of their lives and liberty. IHRL is quite protective of all lives, including the lives of terrorists, and holds the state accountable for any loss of life. Accordingly, the law enforcement paradigm may seem burdensome to governments in dealing with terrorists, particularly terrorists who employ terror to undermine the existence of the government itself. However, applying the law enforcement paradigm to the terrorist can be valuable politically, as it delegitimizes the terrorist by placing him or her in the same category as any other common criminal. It can be effective. The United States has arrested and successfully prosecuted in civilian courts a number of al-Qaeda terrorists. And finally, this is important, the law enforcement paradigm may be the only option the state has available to it under international law, where the actual or threatened hostilities with a terrorist group has not yet triggered the state's right to use an armed response in self-defense under international law. Now, I just want to make clear, I'm not arguing that the conflict Hamas is a law enforcement issue, but I am trying to draw a distinction between law enforcement and the law of armed conflict, just for purposes of background. So this leads me to the other paradigm that has been used to deal with international terrorists, the armed conflict paradigm. Under this paradigm, if a terrorist group can be considered to be in an armed conflict with a state, it can be dealt with under the principles and treaties applicable to war, including, importantly, the principle of military necessity. Based on this principle of necessity, the armed conflict paradigm affords governments greater options to deal with the terrorist, including the use of lethal force as a first resort. This means, in theory, that the government can target any member of a terrorist group that has at least as a minimum, has a combatant function at any time, even when he or she is away from the zone of active hostilities. This is because the individual is being targeted based on his or her status as a combatant, and thus is a lawful military objective. This status-based targeting is a key feature of the armed conflict paradigm. It can be hard to apply in practice because of the difficulties of identifying who the members of the group are, but unless and until they engage in hostilities. However, assuming a proper identification under the armed conflict paradigm, the members of the terrorist group lose any protection from direct attack and are therefore fair game for the state to kill, subject to compliance with certain prohibitions against impermissible means and methods of warfare, such as perfidy. Thus, while the Bush administration's law-free zone theory did not work, under the armed conflict paradigm, the combatant terrorist is subject to a rather thin set of protections. Until he or she is captured or rendered combat ineffective by wounds or sickness, he or she has no protection from being targeted with lethal force as long as the weapons and methods used are lawful under international law. Of course, the law of conflict balances the rights to target combatants in this way and also to target military objectives with many provisions for the protection of civilians. In fact, the two core principles of the law of armed conflict we talked about today, distinction and proportionality, are really exclusively dealing with the protection of civilians and others not participating in hostilities. These principles do offer substantial protections for civilians, but yet these principles offer far less protection than the law of enforcement paradigm, which would not permit any use of lethal force expected to result in civilian death. For example, the proportionality principle requires that those launching attacks on combatants and valid military objectives assess the likely incidental effects of these attacks on civilians and civilians' properties, and not launch an attack if this collateral damage would be excessive in relation to the military advantage anticipated to be gained. And this is a key difference from the law enforcement paradigm. If the effects are not excessive, the attack is permitted. This means that the armed conflict paradigm does envision that there may be permissible levels of civilian loss resulting from an attack. So from this perspective, the armed conflict paradigm would appear to give wide discretion for states to act aggressively against terrorists and terrorist groups. While the paradigm does limit attacks that will result in excessive collateral damage, as Professor Korn was talking about, it seems to me the law can't go much lower than the level of civilian loss already permitted by distinction and proportionality. Otherwise, we would turn a humanitarian law on its head and actually sanction attacks on civilians that either by design or lack of care will result in high levels of collateral damage. In an earlier age, this might have been permitted under the doctrine of reprisal, but is rightfully considered illegitimate today under international law. Of course, the manner in which one applies the armed conflict paradigm to the problem of international terrorism will be determined by more than just what the law will permit. Much also hinges on how a state's application of the paradigm will be perceived by those who may be affected by military operations or by the world at large. There also may be concerns that attacks will result in civilian deaths that will be perceived as an excessive response under a proportionality, a jus ad bellum proportionality analysis, which is different than proportionality in international humanitarian law and really deals with the legitimacy of using force at all against an enemy. For this reason, a state may adopt more restrictive rules of engagement for the conduct of its counter-terror operations to ensure legitimacy, reduce the risk of any collateral damage, and minimize mistakes. These are policies that states adopt and are enforceable as orders for their troops. But please don't confuse them with the law. My point here is that states adopt rules of engagement, and I know I heard a lot today, it sounds like some frustration with the rules of engagement with respect to the conduct of our operations. That's different than the law. The law itself allows substantial flexibility, but the rules of engagement may be more restrictive on particular operations for a variety of reasons, not simply dealing with what the law requires, but what the state decides it's necessary to do for its own operations. And I wanted you to consider in this connection the policy adopted by President Obama in May 2013 for targeted killings of terrorists outside of active battlefields. And these included elements that are far more restrictive than the armed conflict paradigm requires. For example, according to these criteria, before a strike is approved, there must be a near certainty the non-combatants will not be injured or killed, and a determination that capture is not feasible at the time of the operation. Admirable as these may be, requirements like these go beyond what the armed conflict paradigm requires, and in fact borrow heavily from the law enforcement paradigm. According to the U.S. administration, they are in fact standards the United States would like to promote. But it does not mean the United States believes that as a matter of law, the law enforcement paradigm governs its counter-terror strikes against al-Qaeda and associated forces. But it does reflect a U.S. perception that full application of the armed conflict paradigm and its counter-terror operations needs to be balanced with other considerations to preserve legitimacy, maintain morality, and show respect for the law. And I suspect these same considerations motivate the restraint Israel has shown in conduct of its military operations. I'm not advocating that states use or not use the maximum authority granted by the law. That's a decision each state must make in its rules of engagement. Rather, I'm saying that at its limit, the law already permits a great deal of violence. Further, even if we were to come up with the new definitions of terrorism or terrorists for purposes of prosecutions for crimes, which I think is appropriate, I think we need to understand how the definitions will be used in the law of armed conflict context. If they are to be part of a new legal regime that is even more permissive of attacks that result in greater collateral damage, then I don't think I could really support that. And that's my personal opinion. Now, I would like to talk about one area that I do think we could see some improvement, and that's in the area of prosecution and defining sanctions against terrorists. And I think that the description today of activities where people have intentionally tried to exacerbate collateral damage, that should be a crime. It's not actually defined as a crime in non-international armed conflict in the Rome Statute for the ICC, but I think it should be. At least it should be an area we should pursue. And there should be sanctions granted against that. That is as much a crime as the direct attacks on civilians themselves. Now, whether or not the civilians themselves are voluntarily participating in hostilities by becoming voluntary human shields, and I do hope that you understand that in the direct participation hostilities report that the ICRC worked on, that Professor Jackson talked about, the conclusion was that they were directly participating in hostilities, but it's so hard to decide whether they are voluntarily doing that or they're forced to do it. But whether or not they're doing it voluntarily or not, if people are soliciting or forcing someone to be there in order to exacerbate collateral damage, then I do think that's a basis for a crime under international law. And that's something we should focus on if we're going to talk about as maybe a kind of form of terrorism as well. Thank you.
Thank you very much, Professor Shuttler. And I think after we heard our both speakers from the United States advocating for a separation between the term terrorism in the context of law enforcement and the issue of the rules applicable to the fight against terrorism in the context of armed conflict, it would be very interesting to hear our next speaker, Dr. Hili Mudek-Even-Chen, whose PhD and book is really about the connection between the two regimes. So Dr. Mudek-Even-Chen is a senior lecturer in public international law at Sha'arei Mishpat Academic Center. She's the author of the book Terrorism in International Law, Combatants and Civilians in Modern Battlefields. Her other publications have dealt with children in armed conflicts, targeted killings, occupied territories, and women as victims of sexual crimes in armed conflicts. A few years ago, Dr. Mudek-Even-Chen was invited by the Special Representative of the United Nations Secretary General for Children and Armed Conflict to speak on her research about children terrorists. She is currently working on a book on national identities and the right to self-determination in multinational states. Dr. Mudek-Even-Chen, please.
So thank you very much. I would like to thank Shurat HaDin and Nitsana Darshan-Leitner for inviting me to participate in this very comprehensive conference. Okay, so the time frame is quite short, so I would just start up. I would like to begin with saying that I actually do agree with many of the conclusions of my former colleagues to the panel. At first, I thought it would be only Professor Van Lendingham, so I thought it was kind of a womanly sisterhood, but then I understood that it's something greater than that. Anyway, so I would also suggest that I do not see a need or a great need to change the current laws of war, but rather to reinterpret the current existing law. And also, I would like to say that even if we thought it was necessary, I do not really see a realistic option to do that, because there are there are not quite a few states that would like to do that for their own reasons. Some states that are just not involved in armed conflicts and do not see the need to change existing law. Others that just do what they want. I would not mention names, but you can figure it out. And so what I would like to say is that indeed, in other branches of international law, mostly law enforcement branches of international law, there is a definition of terrorism that includes the fact that terrorist acts are perpetrated against civilians, and they are done with an intention to influence a government or an international body and to make it apply a certain policy or abstain from it. And I think that this kind of definition is not really relevant for IHL. IHL, or the laws of armed conflict, if we have to, I don't really see a need to distinguish between these terms. So this law, anyway, I don't think that it should apply this kind of definition, and I would try to now talk about the challenges that IHL faces, that terrorist pits before IHL, and I would claim that there are other aspects that IHL should take account of when dealing with terrorism, and not those that were set up by the definition of terrorism that I just mentioned. So the first thing would be, as Professor Schottler suggested, the paradigm that is now used to deal with IHL, to deal with terrorism within IHL, which is the laws of armed conflict paradigm rather than the law enforcement paradigm, suggests that indeed whenever there is a resort to armed force between governmental forces and non-government and non-state actors, then the laws of armed conflict can be applied. And this paradigm, of course, influences the rules of engagement and the treatment of terrorists in the battlefield. The other thing is the question of what is the implication of the fact that terrorists do not distinguish themselves from civilians. I think this is the major aspect that IHL has to account for, and not primarily the fact that terrorism is directed against civilians. It is rather the idea that terrorists do not distinguish themselves either by targeting civilians, but also by not distinguishing themselves from combatants while directly participating in hostilities, and also the fact that they hide among civilians when directly participating in hostilities. All of these subjects, of course. Sorry. Here. So I thought. Yeah, you hear it now? Oh, sorry. Okay. Yeah, thanks. So yeah, I was saying that we should emphasize the point that terrorists do not distinguish themselves from civilians in three aspects. The first is that they target civilians. The second is when they do not distinguish themselves from civilians when directly participating in hostilities. And the third aspect is when they are hiding among the civilian population when they are directly participating in hostilities. And this has several implications. The first is, when I mentioned the previous definition of terrorism, I said that it emphasized that the point that terrorist acts usually are committed against civilians. But can we consider the fact that terrorist acts in the battlefield within the paradigm of the laws of armed conflict could be also perpetrated against combatants? And I think, of course, they can. Because when terrorists do not distinguish themselves from civilians, then they are perpetrating war crimes. And of course, they should not be endowed with a POW's status. And therefore, the fact that they also target combatants and not only civilians should be taken account of. The second aspect would be, of course, the question of the direct participation in hostilities that was, of course, discussed before in the morning panel, and as the ICRC guidance suggested, there should be changes in rules of engagement towards terrorists and persons who continuously participate in hostilities by being an integral part of a terrorist organization or a non-state organization, and other rules of engagement that should be directed towards persons who only directly participate in hostilities, but in a sporadic manner, as the ICRC guidance on direct participation in hostilities suggests. But we should nevertheless remember that the ICRC guidance, that the ICRC itself changed its point of view, and while it's previously supported a very strict dichotomy between civilians and combatants, it now takes into account the fact that there might be persons who do not deserve the combatant status and nevertheless can be targeted throughout the whole period of the armed conflict because they are continuously integrated within an armed group. And this is a very considerable change that has happened without changing the existing law, but just through the reinterpretation of it. The principle of proportionality, which was discussed in the previous panel, is also an issue that should be taken account of by the reinterpretation of IHL. It was discussed before, but I would like to point to a point that I think that was not so deeply delved into. I also don't have the time to delve into it too much, but I would just like to mention it. I think it should be understood that when terrorists hide among civilians, they abuse, of course, it is understood that they abuse the principle of proportionality. And therefore, there is the question of whether this principle should be reinterpreted in the context of the counter-terrorist force. There have been some suggestions of how to reinterpret it while trying to face the challenge of these terrorists that try to abuse it. And maybe I could relate to it in the question and answer session. The last thing I would like to mention is the fact that terrorist acts are also perpetrated in occupied territories. And we have seen it in the territories administered by Israel, and of course also with the Coalition Provisional Authority administration experience in Iraq. What I mean when I'm saying that is that these acts are committed under the laws of war or the laws of armed conflict paradigm. That is to say, they are not necessary. They cannot necessarily be treated, even in occupied territories, under the law enforcement paradigm. And this perhaps might seem quite obvious to some of the people that are sitting here, but it is not quite obvious to the law, because the law of occupation is mostly a law enforcement paradigm. And actually, it is quite silent on the integration between the laws of armed conflict paradigm and law enforcement paradigm. That is to say, it is most likely that the law suggests that terrorist activities that are perpetrated in occupied territories should be governed by the law enforcement paradigm and not by the law of armed conflict paradigm. It was even alluded by the Israeli Supreme Court when in the targeted killings dicta, when it suggested that the targeted killings should be a last resort, and it did not really explain it, but I think that what was behind this decision was the idea that in occupied territories, the occupying power has effective control, and therefore it should resort to detention and to criminal law procedures rather than to the procedures under the laws of armed conflict. Nevertheless, in the last years, it was thought that a mixed model should govern the use of force in occupied territories. And whenever the occupying force does have a high level of effective control, then it should resort to human rights law or to the law enforcement paradigm. But when this measure of effective control diminishes, then the paradigm of the laws of armed conflict can be activated. So I think, sorry, okay, I'm concluding. And so what I was trying to say is that, of course, we know that terrorism posits before states that are trying to fight terrorism new challenges. And I think that the reinterpretation of existing law it suffices for IHL, and we do not necessarily need to look for we do not need to look for a new law from scratch. Thank you very much.
To use the right microphone. Thank you, Dr. Roderick Evan-Chen. And now I would like to introduce our last speaker, and not least, of course, Professor Boaz Ganor, who is the only non-legal expert here, but I think he's the one that maybe doesn't need an introduction. I was trying to look in the morning in the Israeli laws. I'm sure that somewhere there is a law that forbids to have a conference with the title Terrorism without having Professor Ganor as one of the speakers. So I'm delighted to have him here in this panel. Professor Ganor is the Dean and Ronald Lauder Chair for Counterterrorism at the Lauder School of Government Diplomacy and Strategy, and founder and executive director of the International Institute for Counterterrorism at the Interdisciplinary Center of Herzliya. Professor Ganor is also the founding president of the International Academic Counterterrorism Community. He's the author of the groundbreaking book, The Counterterrorism Puzzle, A Guide for Decision Makers. His most recent book is Global Alert, Modern Terrorism Rationality, and a Challenge to the Democratic World. Professor Ganor. This one works.
Okay, thank you, Gil, for your kind introduction, and I would like to thank Shurat HaDin and Nitsana for inviting me here. And I actually would like to thank each and every one of you that you had the patience to listen to the last speaker in the last panel, which happened to be me. So thank you all. I've started to be interested in the subject matter of terrorism about 30 years ago. It was in my military service, and I found myself dealing with counterterrorism analysis, and I was fascinated with this subject matter. And when I started to earn my academic degrees, I decided to focus in a subject that was not being regarded as an academic whatsoever. But my first academic article in early 80s, and I reveal my age, the first article was on the terrorism definition. And since then, I'm arguing, I did argue back then, and I still argue today, that not only that there is a need to define terrorism and to agree on one objective international definition for terrorism, I am still arguing that it's impossible to counter effectively terrorism without reaching an agreement on such a definition. I have to say that from time to time I feel like a salmon fish swimming against the stream. I'm always in a minority when I speak about the definition of terrorism, even if it's among my scholar friends, if it's with the decision makers, which I happen to speak about this subject, and also, as we are today here, with legal experts that almost all of them disagree with me on that. So I would be a little bit a party breaker with this panel as well, being a minority and arguing the same argument, that there is a need and it's possible to reach an agreement on a definition of terrorism. So in my view, as I started to say, the definition of terrorism is a fundamental counterterrorism tool which we lack today in the international arena, and it's actually an obstacle for us to reach an international level of cooperation to deal with a growing threat of global terrorism. Most of the speakers today refers to the IAGL. The IAGL is very important. I'll speak about it in a moment, but it's only a partial element of counterterrorism. Important one, but still it's only part of the overall picture of counterterrorism. And I would argue that at least as we see terrorism growing today, without a definition of terrorism, we will not be able to reach the level of counterterrorism which is needed to deal with future terrorism. And I'm speaking about non-conventional terrorism, CBRN, chemical, biological, radiological, nuclear, and so on and so forth. I would like to argue that how can we fight effectively terrorism without agreeing on what is terrorism all about? What is this phenomenon which is being called terrorism? What is the common denominators for terrorists around the world? How can we outlaw a terrorist organization without agreeing on a definition of terrorism? Yes, we can outlaw a terrorist organization. We will rely on the definition that we have in our own state. So Israel will outlaw a certain type of groups, and United States will outlaw other groups, and the European Parliament will make a stupid decision that the military arm of Hezbollah is a terrorist organization, but all the rest of the organization is not a terrorist organization. Everybody can play any way they want with the definition that they use. But as you can understand, this is, of course, counterproductive and no more than lip service. How can we outlaw incitement for terrorism if we do not agree what terrorism is all about? How can we forbid a membership in a terrorist organization if we don't agree what terrorism is altogether? Now, it's not a problem that we have lack of definitions. Actually, it's just the opposite. I recommend each one of you to read a book that, maybe the first book that I read on terrorism. It's called Political Terrorism of Professor Alex Schmidt. It's, I don't know what, 500 pages, about more than half of it is dedicated for different definitions which are being used around the world for terrorism. If I'm not mistaken, it's about 109 definitions that he found, official definitions, scholarly definitions, and so on and so forth. There are two main arguments against the definition of terrorism, against even the effort to reach an international agreement on a definition of terrorism. One is that this is a too subjective term. And of course, everybody is using this slogan that seems so well accepted all over the world, and I beg to differ with the logic behind that, which says one man's terrorist is another man's freedom fighter, which means anyone who's fighting against me is a terrorist, anyone who's using the same tools, the same tactics, the same modus operandi against my enemy is a freedom fighter. In a minute, I will refer to that. The other argument against the definition of terrorism is that why should we need it? We already are very successful in countering terrorism with the legal codex that we have today, if it's the criminal codex, if it's the laws of war, the IAGL, and so on and so forth. Security Council resolutions have found a solution to overcome this problem of lack of definition. They forbid the activities that terrorists are doing. So you have a security resolution which is forbidding hijackings or suicide attacks and so on and so forth. That's fine. But again, it's not good enough to deal with the fundamental essence of terrorist organizations, terrorist activities, and so on and so forth, which are not just in the military battlefield altogether. The definition that I suggest to use is short, it's precise. As far as I can say, I think it's objective, and it is the following one. Terrorism is the deliberate use of violence aimed against civilians in order to achieve political ends. That's it. 3 elements. Use of violence aimed against civilians in order to achieve political ends. And you can put in the political ends many, many different types of goals that terrorists are trying to achieve. By the way, to try to achieve to create a caliphate state, it's also a political goal. It's a religious goal, but it's also a political goal. That's why it also falls into that concept. It doesn't deal, the definition that I use doesn't deal with the question, are there combatants or non-combatants, like the American official definition. State Department definition deals with terrorists. Terrorism is the deliberate use of violence aimed against non-combatants. I beg to differ. Because from the point of view of the United States, an attack against the American ship, the warship, the Cole, it's terrorism, not in my view. An attack against the Israeli soldiers, in my view, if it's deliberately aimed against soldiers, it's not terrorism. It's guerrilla warfare. Don't get me wrong. Anyone who's attacking my soldier is my enemy. And I think I have all the right in the world to fight back and even to kill him before he's conducting this activity. But from the moral perspective, I do see a whole difference between certain people who deliberately attack military targets and those who goes and deliberately attack school children and run over on civilians in Jerusalem and so on and so forth. So it's okay, so no need. It's just a break to see where I am. Okay. One word about one man's terrorist is another man's freedom fighter. And this is a whole confusion, in my view. And I blame the two sides, the counter-terrorists and the terrorists, by inducing this confusion. Why? Because it combines two different things. It combines goals and means. My friends, terrorism is a mean. It's not a goal by itself. Terrorism is a modus operandi. Freedom or fighting for freedom, this is a goal that we all definitely support. Let me explain that by giving you a quote from Senator Henry Jackson. He wrote that concept. It was published in Bibi Netanyahu's book. The idea that one person terrorist is another man freedom fighter cannot be sanctioned. Freedom fighters and revolutionaries don't blow up buses containing non-combatants. Terrorist murderers do. Freedom fighters don't set up to capture and slaughter school children. Terrorist murderers do. It is a disgrace that democracies would allow the treacherous word freedom to be associated with terrorists. I beg to differ. Freedom fighters sometimes blow up buses and civilians. It doesn't differ between the terrorist and the freedom fighter, the fact that they are blowing buses or not. And who is using or misusing this wrong concept of one man's terrorist and another freedom fighter are the supporters of terrorism as well. Let me give you the quote from the Muslim World League definition of terrorism. If my definition holds one line, well, the Muslim World League definition was published. First time I saw it was in 2001 in Durban in South Africa, the meeting of the of the NGO there. And the definition that they suggested hold 4 pages. I will not bother you with the whole 4 pages. I would just give you one article. Terrorism is an outrageous attack carried out either by individuals, groups, or states against the human being. And they explain, against his religion, life, intellect, property, or honor. I would buy that tomorrow morning. It's great. Insulting my intellect, this is a terrorist attack. It includes all forms of intimidation, harm, threatening, killing, and now the punchline, without a just cause. So if you have a just cause, all of the above, it's okay. You can insult, you can kill, you can do whatever you want. So the first thing we need to understand that we need to differ between goals and means, and terrorism is a mean to achieve a goal. Now, this is not an academic drill, what I'm trying to share here. I would like to mention that as a counterterrorism expert who's learning this subject matter for more than 30 years, I tend to believe that all the terrorist organizations which I'm familiar with are rational actors. It might sound weird. Because when I say rational actors, it means that they calculate costs and benefits, and they are choosing the alternative which they believe is more beneficial. Maybe it's not based on my calculus of cost and benefits, but they have their own calculus of cost benefits. Right now, why should they refrain from deliberate attack against civilians? It's easier to attack civilians. You get much more media attention. You will get the same punishment if you will kill a soldier or you will kill a civilian. So why should they refrain from deliberate attack against civilians and attack only military targets? Only if we would have an international agreement. And I think that we can have a wide acceptance, including Muslim countries, including Arab countries. You would be surprised, including terrorist supporters of today, that they have this moral debate inside. They dismiss it by saying, okay, they are killing our civilians, we have the permission to kill their civilians. But we should cling to this moral dispute, and we should use that in order to illegitimate their activity, and the illegitimization is an essential part of the overall campaign of counterterrorism. Thank you.
Is the one that the armed conflict is taken in the context of counterterrorism should affect the interpretation of the laws of armed conflict.
I think, as I explained before, and the preceding panel did an even better job of explaining, is that the law of armed conflict is already so fact-based, it's context-specific. So yes, it takes into account terrorist conduct and tactics and acts, but as specific acts and conduct, and takes that into account when doing a proportionality type analysis, or in determining whether or not the Hannibal method or tactic is lawful under the law of armed conflict. So I would think yes, and it does take that into context because it is very fact-based. However, and I think this is something that the good professor expert on counterterrorism echoed this sentiment. The law of war bifurcates and completely distinguishes the legality of going to war, whether or not you've got a just cause or not, with the actual regulation of armed conflict and the means and methods of war once you're in that armed conflict. And that's because of the problem. I'm not as optimistic as the good doctor is that we're going to ever have a universal definition of terrorism because of the one man's freedom fighter is another man's terrorist. And that's why there is a distinction. One of the reasons there's a distinction between why you went to war doesn't matter. It's how you're conducting yourself on the battlefield matters. And that's another reason that reciprocity is not the sole basis or even the driving basis today for the law of armed conflict.
Yeah, I think obviously the law of armed conflict is dynamic. It does get into the direct participation hostility studies is a good example of how this was interpreted to deal with essentially the question of whether there was a third category of some kind, an unlawful combatant. How do you deal with that? And I think they dealt with it in a way, and it's still not exactly universally accepted. The United States has a broader definition of who could be targeted in an armed conflict as far as a member of a non-state group. But I think that, I think there's going to be some development in interpretation. The question is ultimately where you're trying to go with it. I don't think you're going to be able to interpret your way around some of the restrictions that do apply. There was no interpretation that would allow direct attacks on civilians. There's no interpretation that I could think will allow excessive collateral damage. But then again, of course, the question is, how do you come up with those kinds of balancings? And I think the whole precautions discussion is really important. The danger you have actually is quite the opposite. It's that you're getting people defining standards. For example, the United States and its targeting standards is not making it very clear whether or not these are policy standards or law standards, and it's becoming very confusing as if you read some of the speeches that have been given, they need to make that clearer, or they're going to essentially establish a standard that's going to become the expectation. That's actually what the law requires. They're doing more than the law requires. And some people are going to be expecting that is what the law requires. I think that's really the challenge that you have in keeping that clear. As Jeff said, humanitarian law isn't always humanitarian. I hate to have to stress that. I'd like the idea that we do things that are more humanitarian than the law requires. But that's the one danger as we get into as we do that.
Thank you, professors. And the second question is an argument that I tried to formulate during the discussion here, and it relates to the possible connection between the effectiveness of law enforcement measures and the need of states to resort to armed force. So, and I would like to the speakers to maybe reflect about it. Maybe the fact that we don't have a definition for terrorism in the context of law enforcement is the fact that states enjoy the option to use armed force against terrorism, and in this context, as we understand here, they don't need such a definition. So there is no interest for states now to go into these all negotiations, these political difficulties, try to find a common definition for terrorism.
What I would argue with the question, as most professors love to do, and that is that there is no, states don't enjoy the option of simply deciding that they can use the international humanitarian law or law of armed conflict. There are triggers for it, and those triggers are objective, fact-based triggers. So the United States or any other country cannot simply say, we want to use the law of armed conflict because it provides us the authority to target terrorist members based on their membership, even if they're sleeping. They can say it, but it wouldn't be legal, and it would undermine the credibility of the operation because they have to point to objective factors that trigger that law of armed conflict. It is a binary on and off switch, and intentionally so to expand the protections, the humanitarian protections. Even though Professor Korn said the law of armed conflict isn't humanitarian, it absolutely is humanitarian because the law itself is a restraint. Military necessity started out as a concept of as a restraint on armed conflict. Instead of allowing General Sherman's atrocious march to the sea, instead, Professor Lieber, Dr. Lieber, former soldier Lieber, said, you have to explain why that march to sea and burning everything and how it's going to contribute to your military advantage. So even the idea of military necessity is a restraint.
We actually do in United States law have a definition of international terrorism. We use it in the law enforcement area. So we do have one. It's just there isn't, as Professor Ganor said, there isn't one. There isn't an international one, although there are some ideas that have been put out by the Security Council as to parameters that you could have for such a definition. Sorry.
Also in Israel, of course, you are most familiar with the bill that is not that has not still become a law, but I don't think that states, I mean, we know that states do define terrorism, and also, as I said, in international law instruments that were also mentioned by you and by Professor Ganor. It seems, as I suggested, then, that it is rather the laws of armed conflict that do not really need this definition because they have other challenges that needs to be faced that are not relevant to the definitions in the law enforcement area, I think.
Gil, I have some answers for you, but I see such a long line of questions, so maybe we'll take the question and I will try to squeeze it in later on.
Thank you for your generosity for the audience. And we have two questions.
This is a real question. Can you address the issue where the terrorist actors, which are called non-state actors for some reason, are actually being aided, abetted, or materially supported, let's say, by states, whether it's Iran, whether it's Turkey, whether it's Qatar? And how do you address those issues in terms of the laws, rules of war, in terms of the underlying sponsors, economic or other sponsors of those terrorist acts?
Maybe I will start because I was the only one who was not answering before. This is one of the reasons why I argue that there is a need for an international agreement on one objective definition of the term. Because the problem is that Russia refers to the Chechens as terrorists, but they accept Hamas with red carpets, the leaders of Hamas in Moscow. Turkey refers to the PKK as terrorists, but then Hamas and Palestinian Islamic Jihad activists can come freely and have shelter in Turkey. So the only way to deal with this double language, double policy, lip service, hypocrisy, name it any way you want in the international arena, and refer to the responsibility of states for supporting terrorists is by uprooting this idea that one man's terrorist is another man's freedom fighter. Excuse me, if Ismail Haniyeh was sitting in this empty chair and he would say what he's saying publicly loud and clear, I'm not a terrorist because I'm a freedom fighter, I would answer to him, Mr. Haniyeh, maybe you're a freedom fighter. For the sake of the argument, I accept that you're a freedom fighter. By the way, I don't, of course. I think that we are the freedom fighters because he doesn't accept my right for my freedom in a Jewish state in this region. But for the sake of the argument, let's say that you are a freedom fighter. As a freedom fighter, I'm telling you, I think you have the right to use violence. But then there is a certain type of violence which is forbidden even if you have a just cause like freedom fighting. And this is the deliberate use of violence aimed against civilians. You cannot from now on say, I'm not a terrorist because I'm a freedom fighter. Maybe you're a freedom fighter with a huge question mark. You are definitely a terrorist. And I expect the international community to back this statement once it will be internationally agreed. He shouldn't accept that. I'm not expecting him to accept that. I expect the international community to accept that and to together fight against that, because anyone who deliberately attacks civilians is not the enemy of that certain state, it's the enemy of the whole world altogether.
I'm an IDC government student, student of Dr. Boaz Ganoa, and I was curious by what Professor Richard Vanderling, sorry, I'm pronouncing your last name wrong. Okay, so you said that the existing law is enough, and I'm wondering how you would teach students and other legal experts how to implement these laws in the political arena. Like, I agree that if new laws were implemented, they may not turn out as expected, but how would you specifically teach them to use the existing laws?
I think the same way that we teach soldiers, we come up with scenarios and reduce the rules to simple concepts and basic principles, and then we train on particular scenarios. And providing scenarios with clear explanation, and then putting individuals into those types of situations, into that scenario, I think is one way. But I think you're speaking to a broader issue, and that is how do we mount an effective educational, informational campaign to counter groups like Hamas and Hezbollah and others that support them with their twisting of the information. It's a continuous educational process. It's continuous events such as this conference that will work to educate one person at a time and one populace at a time.
In your in your world, is it okay to negotiate with terrorists after you define them? What it is?
Since it's a little bit operational, that's my job here, so I would try to answer your question. Well, let me say it that way. I had the pleasure to work with Bibi Netanyahu on his book, Fighting Terrorism. And he was very, very clear in his criticism on anyone who deliberately, or excuse me, anyone who negotiate with terrorists under any condition, extortion, hostage barricade situation, kidnapping, you name it. And what happened when he was the prime minister, we all know, in the last case of Gilad Shalit. So I'm trying to be humble. With all due respect to myself, I'm hardly a scholar, definitely not a prime minister. And what I learned from that maybe the harsher person in the world, maybe with the exception of Minister Landau, who's sitting here, which is harsher than him on that matter, but one of the people who's very strong in their beliefs and policies of not negotiating with terrorists, at the end of the day, negotiated with the terrorists and came to a deal. In my view, a bad deal, but never mind, came to a deal with them. Meaning, probably what you see from there is different than what we see from here. And under certain circumstances of extortion, hostage barricade situations, sometimes you need to negotiate with terrorists. It doesn't mean that you need to surrender to terrorism and to surrender to their demands and so on and so forth. I wouldn't forbid in any case, the negotiation with terrorists. Okay, I'll stop here.
Hi, my name is Faith Collins, and similar to the premise of the other lady that spoke, if we accept that the law is sufficient in and of itself as it stands with possibly some developments, how does that practically work on the ground in Western democracies? For example, with the rights of the law, such as habeas corpus and due process of the law. In Western democracies like the U.S., we have the difference between the way we try somebody under a military court versus a civilian under civilian courts. How do we prevent things like forum shopping? How do we put a unified standard to this, practically speaking? I know education is great, but how do we work this out on the ground as one from the younger generation who's plowing this field?
Well, you're talking about in the dealing with the prosecution of enemy combatants in something like a military commission. And I would submit to you the military commission, you can have a debate over whether we should be using military commissions or we should be using military court-martials and so forth. I'd submit to you, if you took a look at a military commission today, you'd find that its rights, it's protective, a very protective set of rights. I would stack it up any day against an international tribunal for sure. There's a great deal there. There's done a lot to reform military commissions. Military commissions have a checkered history for a lot of other reasons, but I think they work well today. I think that you do have to distinguish between the rights of the enemy combatant and what he has in the battlefield. Like we said, the armed conflict paradigm is not the law enforcement paradigm. You can engage him on a different basis. When you capture him, there's long-term war. And how long you're going to hold people and how are you going to terminate their detention is an open question. So you may make some compromises, but it's not going to be in the area of compromising to make it harder. It's going to usually make it somewhat more regulated. But I would, on your question about prosecution, I think that our military legal system is a pretty strong, American military legal system is the only one I know of. It's pretty strong.
So you would say to try them as in our military courts versus civilian courts?
That's a choice the state can make. I think I actually am an amicus in favor on a military commissions case right now. And one of the reasons I'm involved is I think it's important to maintain the option of having military trials. Our military courts are expeditionary. We can hold them outside the United States. As an expeditionary military, we need that tool. We can try people. If we don't want that, we can try everybody in civilian courts. Some countries have done that. Our civilian courts are also very strong. So it's a choice we make.
Okay, we have 2 more questions, and I want to let them go forward, but it's got to be a 10-second question. And panelists, let's do a 2-minute answer, okay?
We can just nod.
Question for Professor Ganor. According to your definition of terrorism, would you consider the following case a terrorist incident? A uniformed soldier on leave from base, waiting at a bus stop to go home for the weekend, and a terrorist motorist comes and tries to run him over. Same thing with a police officer or law enforcement official. Is that, according to your definition, a non-civilian? Is that considered a terrorist attack?
Thank you for your question. It's a great question, and I would expect that question to come up. Actually, you could make it even harder for me. You could ask about a police officer or some other. So I would say you need to take my course. It's a 1-semester course that I would explain all the options. But even under my definition, of course, there are gray zones and gray areas. But this is not a gray area because this is an easier case for me to answer. And I would say yes. If it would have been a deliberate attack against a soldier who's hitchhiking, but the terrorist or the one who defends him would prove that he deliberately attacked the civilians, the soldier in this hitchhiking place, but he could attack a civilian 10 meters away, I would regard to that as a guerrilla attack and not as a terrorist attack altogether at the end of the day. I want to lift the fire from the civilians and to aim it towards the soldiers. By the way, the tool that I'm using in order to make this decision and to judge if it's a terrorism or guerrilla warfare, it's reciprocity. I'm asking myself, what are the rights that I have? And I would tell you that I think that we have the right for targeted killings against terrorists, not only when they are armed in the battlefield, but also when they are sleeping in their bedrooms in their own houses. So if it's a soldier on our hand, or on our side, if it's a terrorist or a guerrilla warrior on the other side, I think you have the right to deliberately attack him if this is, if you distinct that from the civilians.
This question is for Dr. Mudrik Evan-Chen. You used in your statement a significant distinction between treatment of actions in an occupied territory versus treatment of actions otherwise. I'd like to know, the question is, how do you base your definition, what is your definition of occupation? The reason I ask, because specific to the West Bank, in my layman's understanding, occupation would require that there had been a sovereign power which is now being occupied.
Okay. I was not going to go into this political debate, and I did not mean it. I just referred to the legal definition of the Hague regulations, which suggests that the occupied territories, occupied territories are territories which are taken by a hostile army and replace the government, the existing government, whether it was sovereign or not. Whether it had a legitimate, a legal authorization to rule this territory or not. So it's not the question of sovereignty, which is under debate, perhaps under the Geneva Conventions, but not under the framework of the Hague regulations. Well, this is a very legalistic matter, and I'm not sure it's relevant here. What I was talking about is just the fact that when an occupying power stays in an occupied territory, it very much resembles a government that rules its own independent territory, and I meant to make a distinction between such a situation and a situation in an armed conflict in a territory which is not taken by any ruler. And that was the distinction. I was not referring to the problem of whether there is occupation politically or not.
Okay. If I could quickly add to that, I think a lot of it is that de facto analysis. If it looks like a country is exercising effective control over an area, if it looks more like peacetime, law enforcement rules apply. You don't do things like targeted killings. But if it looks more like an armed conflict and you're fighting folks, which means de facto you don't have effective control, then the law of armed conflict will apply. So I think it can be a sliding scale, and it transitions between the two.
Okay, thank you for the panelists. Please join me.